hearing to order. We'd have one case on the docket, which is Enery Holdings, LLC, case number, I believe that's 6248-3. Let the record also reflect that we have a full complement of hearing board members. All are present. We have several exhibits, and let me mark the first exhibit. Petitioner exhibit number 9, the MDP calculation and gas usage. There's another exhibit number 10, email between parties dated 11/3/2025. And then there's a respondent exhibit C, proposed regular variance conditions. I'd ask, since we're on the record, are there any individuals present to provide general public comment or evidentiary testimony?
No.
Let the record reflect that there are none. Who do we have representing the petitioner today?
Good morning. Excuse me. My name is Olivia Goldstein. I'm the president of Enery Holdings.
What your last name, please?
Goldstein.
And for the respondent, who do we have?
John Jones on behalf of the executive officer.
Okay, Mr. Jones. Mr. Verdugo-Peralta, you are attending remotely, as am I. Just to be very clear, are there any individuals within the room there with you?
Only Mr. Peralta.
Okay, and your agenda was posted pursuant to the Brown Act, correct?
Yes.
Today, I'm participating in accordance with AB 2449. There are no individuals in the room with me, and I'm traveling on official business for another governmental agency. All right, Ms. Goldstein, floor is yours. Opening statements.
Thank you so much, Chairman.
And also, hold on one second. Do we have any witnesses?
Yes, my Director of Compliance, Mike Munoz, will be joining us. I think he's remote. Would you like him to introduce himself?
Well, actually, we're going to perform the witness oath. Mr. Jones, you have any witnesses, sir?
None we intend to call. We do have staff available if there are questions from the board.
No problem. Okay, Mr. Munoz, why don't you appear on the camera so we can administer the witness oath?
Chairman Ali, I believe I am on camera.
Okay, there you go. I see you. Raise
Ready
your right
to
hand.
swear.
Okay. Mr. Munoz, do you affirm that the testimony you're about to give in this matter is the truth, the whole truth, nothing but the truth?
I do.
Thank you, my friend. All right, Ms. Goldstein, your case.
Thank you. So good morning to the hearing board. I'm in front of you today to request an extension on a regular variance that was granted on 7/31/2025 with an end date of 10/29/2025. We are seeking an extension of the order from that case number 6248-3 via a new petition 6248-4 with the variance set to extend through July 31st, 7/31/2026. The hearing board previously found that Enery Holdings complied with the 6 findings required for the variance. So in the case of this variance request, Enery continues to meet those 6 findings, and I'm happy to go through those now if the board's ready.
Go right ahead.
Sorry. For clarification, Mr. Chairman. Yeah, just a point, Ms. Goldstein, you mentioned a new petition 6248-4.
Yes.
Okay.
We were indicated by the clerk that we needed to make a new petition because we were past the date of the last petition,
Right.
but it's essentially an extension to 6248-3.
So, well, you missed the deadline to file for the last one. It was supposed to be September, let me see.
The 12th, and we filed on
You filed
September the 30th. That's correct.
So you missed that deadline. So then
Yes.
then you filed if you filed the petition you filed that we have, is that
That's
It's marked as -3, but it should-
6248-4.
It should be -4.
Yes.
For our end, since it is acting as a continuance, we decided to keep it as the same case number since it is acting as a continuance for that case. So we kept it as -3.
I know, but did they miss the deadline for it to be the public notice and to be a continuance is my question. And for the both parties, and should it be considered as a new case?
We didn't consider it a new case. It's acting in as such as a continuance, so we kept it as the same case number. They did miss the deadline for the petition for an extension, but we just, for our office, we kept it as the same case number.
I know the case number is the same, but when I look at the public notice on the web, it didn't say continuation, it says a regular variance.
So, Mr. Balakapalan, what do you propose, my friend?
No, I'm just trying to get clarification because there is a impact. If it's a continuation, then the 1 year, there's an increment of progress that is needed for the variance if it's more than a year. And it looks like you were asking till the 10/29/2026.
We're asking until 07/31/2026.
07/31. Okay, so
Yes.
that'll be within a
It
year.
would be a year from the date of our last hearing.
Okay, so that's why I'm asking for the clarification. If it's a new petition, then it's okay because, it's starting from today.
I understand. Based on our communications with the clerk, we were asked to implement a new petition,
Right.
but I'm not sure how they're handling it here.
Yeah, and that's what I'm confused because if you're asked to submit a new petition, then it's new, otherwise it's a petition to extend the date, basically a modification. But you missed the deadline to get the public notice in time, to
Yes.
do that. So
And
makes-
I'm sure my director of compliance can indicate why the deadline passed before we submitted our request. And therefore, we're told that we had to indicate a new variance request.
and I don't know, Mr. Jones, if you had anything to offer on this one.
That's essentially correct. They filed what they were told to file. This is essentially a continuation. We have this date to make sure that they had the notice requirement met.
Okay.
All things being the same, we would prefer for it to be a new petition. Because that's what the clerk told us to do. And also Mr. Balakarian is indicating an issue that could come up in that we have a time frame, a limitation of 1 year, if it's a continuation. So if our preference matters, we would prefer that it be a new petition number.
Okay, so Mr.
And I think that is okay. We just have to change it, to -4.
Yeah, so
Okay.
what we have before, do we consider this -4, the one filed September 30th?
Maybe I keep your guys' discretion if you want to do that. But I'm pulling up the notes and see what it was noticed as.
Yeah, I can read it to the record,
Yeah,
we'll hold a public hearing to consider granting of a regular variance.
Okay.
It didn't say about a modification or extension. That's, the notice didn't reflect, which is fine, I think as long as we change it to -4.
Mr.
And then we
Chavez,
can consider it.
Mr. Chavez, can you turn your microphone on, my friend? And so you're gonna actually look up the notice to let us know exactly what was published?
We're pulling it up right now.
Okay, very well. All right.
What do you think? Is it change it -4?
Change the four.
Yeah, we're fine, yeah. And it looks like it was October, so the date is okay, the 30 days notice was done, so October 1st, so it's good, so we're okay.
It was noticed for with the -3 case number.
Yeah. But the language,
It was noticed as a regular variance request, not a continuation, correct, Mr. Chavez?
Correct.
Okay, so then in the motion, can we just clean this up?
Yeah, I think we can deem it, I mean, we can do it now with the bar is concerned,
Yeah.
that we deem
Right.
it as -4 and
Okay,
proceed.
so the case, so Mr. Chavez, would you want to ascribe the case number?
So it would be 6248-4.
6248-4. Okay, we've cleared that up. Any more questions, commentary from members of the board before we move on to Ms. Goldstein?
no, I think
All right.
that clears.
Perfect, good deal. All right, Ms. Goldstein, your opening arguments.
Thank you. So to reflect, I am now in front of you today to request a variance that is similar to the variance granted by this board on July the 31st, 2025, that had an end date of October 29th, 2025. We seek a new variance with case number 6248-4, the extension now being for our request in our petition through July 31st, 2026. But based on the conversation here, I think we could request for the full year, if that's correct, to 10/31/2026. In case number 6248-3, the hearing board previously found that Inari Holdings complied with the 6 findings required for the variance, which I will go through now. In finding 1, that the petitioner for a variance is or will be in violation of section 41701 of any rule, regulation, or order of the district. The petitioner continues to be in violation of Rule 2012C3A, as we are still unable to transmit SEMS data because we don't have a copper modem line. Condition 2, that due to conditions beyond the reasonable control of the petitioner, requiring compliance would result in either an arbitrary or unreasonable taking of property or the practical closing or elimination of the business. The non-compliance continues to be beyond the reasonable control of Inari because AT&T, a public utility, has still not repaired its connection over the past 90 days. The reclaim rules require that we would use missing data procedures for any hour that we cannot transmit the data via the modem. Exhibit, I think we renamed this to Exhibit 9. Has our calculation for what we would be responsible for over the past 5 days between our previous variance expiring and today's date. It's an unreasonable taking. Any amount is an unreasonable taking because we are not creating emissions. So we are being charged a penalty for false emissions. Condition 3, that the closing or taking would be without a corresponding benefit in reducing air contaminants. We do not, nor have we ever created excess emissions. Number 4, that the applicant for the variance has given consideration to curtailing operations. We're under the jurisdiction of CAISO and we must run when called upon. Number 5, during the period the variance is in effect, the applicant will reduce excess emissions to the maximum extent feasible. The petitioner does not nor has ever created excess emissions. And number 6, during the period that the variance is in effect, the applicant will monitor or otherwise quantify emission levels from the source if requested to do so by the district, and report these emission levels to the district pursuant to a schedule established by the district. Pursuant to the conditions set within Order 6248-3, Inari will validate zero emissions data points for our gas turbine device number D19 by continuously monitoring the fuel gas flow during the variance period. Under the previous order, we have explored alternate options for data transmission, which has led us to consider replacing our DAS and SEMS. So as we replace our DAS and SEMS and experiment with fiber modems and other technology, there may be instances where we're not able to record the data as we're offline. I think that takes care of the 6 conditions. If there's any questions, please let me know.
All right, Mr. Jones.
Good morning, Ms. Chair and members of the board. I think the situation, if anything, that led to them to Henry seeking various relief in this past July have gotten worse. AT&T recently reported additional copper thefts, and this is after they welded their manholes and poured concrete on them, and the thieves were still able to get through. So this situation is, as Ms. Goldstein described, and if anything, it is not going to improve in the near term. So the additional time so that they can update their systems, we think is warranted. We've met and conferred and would not object to the extension that they're seeking at this time.
Okay. Before we go any further, I just want to do a process check. Members of the hearing board, are there any questions before we move on to the witness? Okay. All right, Ms. Verdugo-Peralta, were you seeking recognition?
Yes,
All
sir.
right, go right ahead.
I just had one simple question, and I think I asked
Go right ahead.
this before at the last hearing, but also I just wanted an update whether AT&T has contacted them and given them any type of an estimate or explanation. I understand that it's due to theft, but did they give them any time frame at all when it would be repaired?
I can answer that question, Ms. Madrugo-Peralta. AT&T has told us that we would receive continuous service at the end of September. As Mr. Jones alluded to, other manhole covers were cracked open and the copper stolen in between our site and the AT&T switching office. So it continues to be a whack-a-mole situation where they'll repair one and then, but somewhere down the line, something else will be cut. So AT&T has not given us another finish date beyond September.
I have one question, James. I
Go
just
right ahead.
noticed the prior order had a clause 7 that the parties shall meet and confer to explore alternative methods to communicate data. So have you given up that effort, just going to be waiting for a pipe situation to be ended, or is that still a possibility that you can come with something different that the AQMD would accept?
I can answer that question as well. We have met and conferred, and the answer is a 2-part answer in that technically we believe there is an alternate method. South Coast Air Quality Management District maintains a website where large generators upload their data. And so that would potentially be a solution. Unfortunately, Mr. Lee has indicated to me that that method is unavailable to our size generator according to the reclaim rules, which caused us to move down the road of if we needed to use a modem in order to fulfill the reclaim rules requirement, could we use our current system? And the answer was no, which is what Ms. Goldstein had previously alluded to, which then caused us to, if we can't use our DAS, then we have to backwards integrate to our SEMS. And we're talking about a $400,000 capital expenditure, and then it has to be built. So we have met and conferred. There is a technical solution, but Mr. Lee has indicated it's not available to us. And so we're moving down the road of replacing our SEMS and DAS systems to support the use of a fiber modem.
Mr. Chair, I have questions for Mr.
Go ahead,
Munoz.
sir. Go right ahead.
Mr. Munoz, let me first ask, the order did ask you to file no later than September 12, 2025, if you wanted a modification. Why was it, why didn't you follow the order? What was the delay?
We were trying to meet and confer, and we had a difficulty getting together. Well, first off, on our side, we had a technical issue where we had to decide, could our current system support another kind of modem? So that took a good bit of time as we tried different solutions. And then when we tried to meet and confer, not everybody was available. And so we just missed the deadline. And I don't think that we actually got to a common ground until sometime around the second or third week of September, which had already passed. And so I contacted the clerk, and the clerk said I needed to submit another application because I had missed the deadline. So it was nothing other than we just couldn't get together, and we hadn't completed all of our analysis at the time before the due date.
Because your petition said you were not able to meet and confer, but you did finally meet and confer. And what date was that when you had that meet and confer with Mr. Lee?
I think it was, I'm going off of recollection here. I believe it was sometime the second or third week of September.
Okay. And he
Excuse
mentioned.
me, Mr. Balagopalan. It was on October 8th.
October 8th.
Thank you.
Okay. Now, it does appear from your exhibit, and maybe we have to renumber the exhibit, but I can do that later, that you did not operate at all from the gas logs that you provided the unit, the turbine during the variance period?
We did operate a handful of days in September, or I mean, in August, to conduct a continuation of our RADA test. And we operated, I think, 3 days in September to meet the CAISO's orders. Very few days, unlike previous years, very few days. 3 out of the 30 days of September, usually we would operate every day in September.
How is that reflected in the exhibit that you provided us with the SoCal gas? Because it was showing raw volume was all 0.
The exhibit that was provided was for October
October.
and November to indicate the days between the variance period ending from 6248-3 and our petition today.
Okay.
We are happy to pull the gas logs from the other days if the board would like to see that.
I just wanted to get it for the record, what if you did operate, and it appears from Mr. Munez that the CAISO did ask you to run
That's
the
correct.
gas turbine, and you did. Okay. Now, Mr. Munez, you mentioned that you're looking at the alternative of looking at replacing the SEMS with the new system. Your petition said you got approval from the district, or you're trying to see if that will work because it's a different technology. And would you still be able to transmit data in the new DAS system that you install? We can hear you. You're muted.
Yes, thank you. Other vendors other than Semtech can appear to be able to use fiber modems. They can mimic the DTMF tones that a modem uses, but our current vendor, Semtech, cannot. And so we have both a Semtech DAS and a Semtech SEMS unit. And so we don't think we can backwards integrate a new DAS with an old Semtech SEMS unit, which would cause us to have to replace the SEMS unit. And in the SEMS unit, there's been some improvements in technology from the 1990s when the SEMS were first developed to use lasers with non-extractive methods. And so that's what we're pursuing because they passed the EPA's Part 75 requirements.
Okay, so your proposal, your plan is to then replace the SEMS with the the newer technology and then go with the fiber optics method to transmit the data. So that
Yes, sir.
is that correct?
Yes, sir.
And and the company is committed to that and in process. What's the status of that?
So we're currently receiving bids on the new system. Requests for proposal are out. We have 2 front-running vendors, and one issue that we have to address with AQMD is currently AQMD doesn't have a rule set for the laser systems, laser non-extractive systems. So we're working with Mr. Eckerl at AQMD to see what would have to happen to use the new technology that's been approved by the Environmental Protection Agency.
So that's one of the, so it's contingent upon AQMD's approval of the new technology, correct?
Well, we're going to have to solve the problem one way or another. We would prefer to use modern technology and not 1990s technology. So we'll work with AQMD to see if we can get the laser SEM system approved. If it's not, then we'll have to revert to extractive 1990 system.
Okay. And in your, since you got the proposal out, do you think you can achieve it by next year, October 31st, get the system installed, get the approval from the AQMD, get the system up and running?
We do. We think that the budgeting, purchase, and installation will take about 9 months to do. And the unknown for us is the AQMD part of what their plan is to review the EPA's Part 75 use of laser SEMs. And so that's what we have to address next.
May I ask you, have you said going before the governing board to bring this issue up and maybe getting a rule change? Because right now it allows for large sources to transmit through, to directly on the website, and to make it applicable to major sources, or having AQMD update their integrated system. So the question is, yeah.
I didn't think that was a possibility to do. That would be easier, but I didn't think that was Mr. Lee didn't indicate that was a possibility when we met and conferred.
The only reason I bring that up is there is an agenda item on the board calendar this month, this Friday, to update the permitting system. It mentioned the facility permit system. I'm not sure if it involves just the permitting or the back end, so that's what raised my question. The district is going to expend quite a large sum of money to improve the permitting system, but I'm not sure on the other back end, the data collection system. Okay.
I would like to say, Mr. Balakarian, that that would be, I can't imagine that we are or will continue to be the only power plant that is going to affect this issue. The California Independent Systems Operator has also suffered from this issue, and they've mandated a change from a copper line T1 to fiber. And we're going through that now with CAISO because other power plants are affected. And I think that for the rules to say specifically a copper line modem and no other method is setting up a power plant to just not be able to fulfill its obligation under the permit, because we have no control, as AT&T has shown us. So to the extent that the board could do anything to help us with AQMD allowing a facility like ours to use a web interface, which has already been used, for the last decade with smaller generators, that would be extremely helpful.
Just wanted to go over the proposed conditions. So it's very similar to the previous one, correct? the proposed conditions
Yeah,
that you'll
yes.
continue to. Now, the zero data emission, what are you submitting to the district currently as far as zero data emission? Are you transmitting anything?
We are not transmitting. The order requires that we use a missing data procedure for any run hours. So in our last QSER submission, we submitted to Mr. Lee the calculations for the number of run hours times the maximum a non-start run hour NOx emission, and that is how we're submitting to the district.
Okay, I just want to be clear, because we went through this the last time. The only time you have to do missing data procedure is if you feed gas, if you're running the unit. Is that your understanding?
That is our understanding, and that's what we're complying with.
Okay.
But your question was the method that we're communicating that to AQMD, and the method that we're using is the quarterly QSER report, where we're conducting that calculation and sending it to AQMD.
Okay, when you run the gas and you're using missing data procedures.
Correct.
Okay. All right. So I take it then you will not be contacting AT&T and get an update, and you're moving in a different direction then?
No, we will continue to contact AT&T because we continue to pay for that government service. And so we would like for it to be functioning for the money that we're paying, but we can't count on it. We have to take some alternative action. So that means figure out a way to communicate via modem using a spoofing system, or an even better way would be if the rules were changed so that our size plant could emit or could communicate via the AQMD website.
What I don't see as an exhibit or any evidence provided is what form of communication you're having AT&T, if it's documented in the rules for AT. I'm assuming you have some of that, but it's not been provided. Is that correct?
We have logs of our tickets, our open tickets, if that's what you're asking. I came here as a witness today, and my testimony was what I was relying on, but we could certainly supply you the current AT&T log.
Okay. And you're continue to maintain those logs and make it available upon request by
Certainly.
the inspector.
Absolutely.
Okay. Now, your petition did mention your time getting a hold of district staff and having a meet and confer. At what frequency are you going to continue to do that? And then, because now you're going to go into a critical of trying to get this new system approved. So, at what frequency are you have meet and confer with the agency?
Well, we think that we're going to have to find out who's actually responsible. So in our dealings with Mr. Eckerl, who Mr. Jones helped us get a hold of that office, but Mr. Eckerl, who we thought was, who Mr. Lee said was the responsible party, he indicated that they're only the engineers on it, that there's a policy-driven office in AQMD that we're going to have to move up to. So I would imagine we're going to pull the thread throughout, this month, now that we know that Mr. Eckerl isn't the decision maker, and try to figure out where we need to go. And we're also going to explore what you just indicated, which was a change in reporting, because if we could get AQMD the rules to change and allow major sources to submit over the web, then that solves the problem for not only IceGen, but for all other generators that are going to inevitably face this in a California where copper thieves, are bent on stealing the copper.
Okay, thank you. No further questions for Mr. Munoz.
All right. Ms. Verdugo-Peralta.
Thank you, Mr. Chair. Mr. Munoz, I'm not sure whether you understand or not that we don't have the authority to change any verbiage, even though it's much needed to change it to whether you can utilize newer technology. However, I have a question for Mr. Jones and possibly the engineers that are there. Is AQMD working on either changing the language of that rule to allow newer technology? Because that only makes sense. What Mr. Munoz is saying is absolutely correct, is they're not the one and only that's going to be facing this. I'm sure there are others, and CalISO is going to need them to be pulled online to provide and answer the demand of the amount of electricity that's being required throughout the state. And they roll them out as well as their environmental, whether they are a cleaner technology versus another smaller or possibly even equal size. So if the AQMD is behind the times here and not allowing that, that's a problem for, the entire region as well as the state. So my question is more to Mr. Jones and the engineers that are there, if AQMD is working on correcting this.
The short answer is yes. The rule process isn't a quick one, but ever since July, we've been starting the process to figure out what's the best way to modify it so that we can address this, not only with Henry, with anyone else. We have the process is, like I said, I'll say in its infancy, but it's certainly something I personally have been working on. So we're working on it. It's all I can say.
And no projection of time.
Well, typically a rule could take over a year. Would like it to be less than that. So I don't have a projection, but my goal would be to get it, certainly before the current deadline. But without knowing, I can guarantee when you account for all the notice requirements and the governing board schedule.
Right, and knowing that process. And knowing that process myself, that's my concern, is that it's going to take such a long time if you go through regular rule process to get to the point of changing that language. And I think this is it's going to become a very urgent situation that we're holding up the availability of CalISO being able to answer the demand by having these other companies available. And right now, if they're going to go through this antiquated process, it's on us. It's on us, AQMD, that this is going to be occurring. So, Mr. Jones, I'm sure you recognize the urgency of this, but if you can possibly in any way get this expedited, of course, that would be a much better situation for not only this company, but the state in general.
I will certainly make my best efforts. It's really all I can do.
I'm sure you will. Thank you.
Thank you, Ms. Goldstein.
I have a question.
Okay. Ida.
Kind of along the similar lines, Mr. Jones, who all are we engaging in this conversation at the district, including, is the executive officer aware?
Well, yes, he's aware, but currently in terms of people we're dealing with, we have the general counsel's office, we have the reclaim team, there are engineers and members of compliance that would need to be involved. I don't have the list grows every time we go through it, but it's a there are multiple parts. I'm essentially in the process of herding the necessary cats in the room to get it done.
Similar to Ms. Verdugo Peralta, really appreciate you continuing to advocate to move that process along. The challenge is reaching the AQMD staff. Can you speak to that? Do we know why that was a challenge for the petitioner?
Some people were on vacation and not everyone was available at the same time. It wasn't.
But people do cover and people do respond when someone's away?
Yes, but in this case, there was a gap. And so we've, as Mr. Megan said, we've worked to make sure that is going to be an ongoing problem. We've certainly have met several times since then. So I don't foresee that be a problem in the future.
Appreciate it. Thank you.
All right, Ms.
Mr. Chair, I did have a follow-up question for Mr. Munez.
Okay, and then we're going to immediately move to closing. Go right ahead.
Mr. Munez, there's nothing in the current order, in the various condition about updating your process in getting the new SEMS and the system going. So would you be opposed to, or maybe, some condition related to that? So there's a periodic update on your process in getting the new system up and running.
I have no, I would welcome that inclusion to the extent that it allows, that it encompasses both INERI and AQMD. We can't do this alone. And so, as Mr. Jones said, the list of people who are involved in it is growing larger and larger, as I just indicated with my conversation with Mr. Ekerl. So I wouldn't oppose it. I would ask that you include AQMD so that we can find a common solution in as quick of a time as possible.
Well, I was going to propose that both maybe come up, confer and come up with some condition regarding that update, regarding the process in getting the new system and getting approval and so forth as one of the condition. I can propose some language coming from both parties, discussing it and proposing it.
We can confer. I think that's a welcome change, a welcome addition to the conditions. We both, it seems, want to work together here to make this happen. As Mike indicated previously, for us, it's on the technical side, it's a longer term project, which is why we're seeking the longer variance here. And it sounds like on the AQMD side, it's a long process to get everybody together and to make these changes. So I think we can confer and meet common ground.
So, Mr. Chair, if it's okay, maybe you can give some time for them to come up with some proposed condition.
Well, first I want to ask Mr. Jones.
We have 15 minutes.
Mr. Jones, I'd like for you to opine on this, or at least weigh in. What are your thoughts?
I don't know that. I mean, this not really is under our control in terms of their updates. So I'm not really sure what it is you're asking of us, but we're certainly willing to cooperate in whatever way we can. So I'm happy to make that representation. But beyond that, I don't know what else I would be able to offer.
Okay, so why don't we go ahead
Dr. Say, the parties are acting in good faith, and we've heard kind of all the challenges they've been facing. I don't know that it's necessary to add that additional condition. We have received all the information that we've been asking, and I believe both parties are working together. I don't have any doubt that will continue. Well, including them continuing to faithfully work on updating their system.
If you look at the order should state that, I think, because if you look at condition.
I think that's an opinion, whether it should state that or not.
It's not an opinion, it's a variance condition. And so what are they proposing is to install a new system. So there should be a periodic update with the district and to the board that it's ongoing and there's communication going on between the two parties. I'd like to see that, in writing, even though it's a good faith, but you saw in the petition they submitted, they were not able to meet for whatever the reason, so good faith is fine, but, I think if you have an order and they don't meet it, then somebody was violating the board order. That's what I'm trying to get at,
Yeah, and I'm not for certain about that. Ms. Verdugo-Peralta?
I was just going to add that according to the variance, it should be stated on there, and I don't have any question that they are acting in good faith, but I think I agree with Mr. Balagopalan that it should be in writing on there to respond to the variance and how it should be. It is in a way a matter of opinion, but I think it's much more to follow the rules of how the variance should be, as well as how they should be responded.
The burden should fall on us to provide the amendment to the conditions.
Well,
Mr. Balapan. May I
I'm
suggest?
not done.
Oh,
Not done yet.
Ms. Goldstein,
Excuse
hold
me,
on
I'm
one
sorry.
second. Hold on, Ms. Goldstein. Ms. Verdugo Peralta, the floor is yours.
Thank you. I just want to reiterate, that we do have to follow how the variance should be and technically. And even though I'm sure that we are all in agreement that they are doing the best that they can, it should be in writing on that condition that they would be responding to and monitoring and giving feedback to the district. So for that reason, I agree with Mr. Balakopoulos. Basically, it's a technical agreement versus an opinion. Thank you.
Dr. Abraham, your
I was
response.
just gonna say, if that is what we want to do, then we should propose the language and put that forward as an amendment to to the conditions that we are going to adopt.
Okay, and it'll
I
be,
don't disagree, but I'd rather have
it would not be
language from
stipulated.
the,
It would not be
Sorry.
stipulated because the district is not agreeing to it. Mr. Pearman, your thoughts?
I don't see why it's necessary. I agree if the parties agree on language, then we can do it, but if the district is opposed to specific language, then I would reject it
Okay.
as well.
well, that's what I'm saying. Maybe Ms. Goldstein can propose the language, meet with Mr. Jones, see if he has an
Right,
objection to
okay,
it
so
or
as
not.
it stands, three of us are not necessarily interested in moving forward with respect to the amendment. So we're gonna go ahead, Ms. Goldstein, we're gonna move to closing arguments, ma'am.
May I just make a comment here,
No,
Chairman
no,
Ali?
no, we're closing. We're done with the last discussion. Let's close.
Very well. In summation, despite our continuing efforts, we have not been able to reestablish our connection via AT&T, though our efforts are ongoing. So we ask that the board grant our variance until October 29th, 2026. That's 1 year from the lapse of 6248-3. And we ask that the board stipulate the same conditions as the order from 6248-3, including item number 7, that the parties shall meet and confer to explore alternative methods to communicate data to South Coast AQMD.
Ms. Goldstein, just a question. Was that the comments that Mr. Balakopoulos stated? Were those the similar requests that he just made?
Yes, I'm asking for the
Right,
variance to be granted with the
Ms. Goldstein,
additional.
right. So
Yes.
we're not meeting it, we're not adding the language. Mr. Jones, go ahead and close the argument, sir.
We do think that the members of the board, we do think that the situation is essentially the same, if not worse than it was before. And so that they've met the 6 factors necessary that would justify a variance to the requested date of 10/29. We certainly would not oppose a grant of that.
All right.
Based on the.
Thank you. On the cleanup with respect to the exhibits, because of the new case number being 6248-1, Exhibit 9 now becomes Exhibit 1, Exhibit 10 now becomes Exhibit 2, and then on the respondent side, Exhibit C now becomes A. Again, 9 becomes 1, 10 becomes 2, C becomes A. Down to deliberation.
Mr. Chair, now to Mr. Abraham said that the proposed conditions should come from the district. I have no problem proposing a condition.
Well, Mr. Balakopoulos, we're not gonna, right, you can propose the motion, but we're not gonna entertain the meet and confer language.
No, I'm not talking about the meet and confer. I'm talking about adding a condition so that before we approve the variance.
So what would the language be? Go right ahead.
The existing condition to add another condition. If you
So
give
what
me a
would-
few minutes, I'll work out a language and we'll provide that.
Okay, any additional deliberation for members of the hearing board?
Dr. Ibrahim here, I believe that the petitioners met the burden of the six items that we're seeking here to move forward of granting this regular variance.
I agree. And just to confirm the district, these are stipulated proposed variance conditions, right?
Yes.
All right, thank you.
So what's your pleasure, Mr. Chair? Should I propose the language or
No,
not?
go right ahead. Absolutely. We're waiting for you, my friend.
Okay, can you give me 5 minutes?
No, we're off the record for 5 minutes. We're back at 10. Why don't we just come back at 10:30? We're off the record. All right, it's 10:30 a.m. We're back on the record.
They're not back yet. They're still outside.
Okay.
All right, the parties are walking in.
They're coming in.
It's 10:30 a.m. We're back on the record. Are all parties present? Okay, Mr. Balakapalan, the floor is yours.
Okay. So I'm proposing a new condition, and that'll be condition 5, just to make so it follows the because condition 4 only talks about after the communication system failure has been resolved. So they're going with the new approach. So here's the condition. I'll read. So proposed condition number 5. Petitioner shall provide monthly updates to the Reclaim Q&A AQMD.gov and Airport Inspector Thomas Lee, Lee at AQMD.gov, and the clerk of the board regarding the replacement of the new SAMS and DHS system. This would include status of the SAMS DHS application for SCAQMD approval and dates of meetings / emails with AQMD staff and purchase orders and installation. I can go back and read it again.
Ms. Gold?
So basically, it's just communication with the agency and regarding the status of the new system.
I'm just curious, Ms. Goldstein, your thoughts on this?
Thank you, Chairman Ali. As Mike said previously, we'd like the communication to be bilateral. So I'd like to see AQMD held to a similar standard. And I also think perhaps can we change it from monthly to quarterly?
Okay.
I think to address Ms. Goldstein's concern number 7 from the previous minute order, the parties shall meet and confer to explore alternative methods to communicate data to the South Coast AQMD would hold AQMD also to the, just ensuring that they are at the table and the conversations are occurring from the district side as well.
Thank you.
Mr. Jones, what are your thoughts on the new amendment?
The meet and confer, we're okay with. Beyond that, I mean, well, it's not our petition. We're not really before seeking relief in that way. So we would object to an order making us act in a particular capacity, but certainly we have been and continue to meet and confer. We have no issue putting that language back in. We only took it out because we didn't do the meet and confer. So
Okay.
it was no longer necessary to have it there. You can put it back. We don't have an issue with that.
All right.
Mr. Jones, do you have any objection to the language I propose?
No.
No. Okay.
All right.
Or the
so
quarterly, if that works better. We don't.
Okay. So let me ask you this, just so we're clear, members of the hearing board, because now we're in deliberation. Are we comfortable with number 7, which both parties agreed to? Are we comfortable with adding this quarterly? I just personally, well, let me hear from everybody. I'm trying to wrap my mind.
Why don't we, Mr. Balgopalan's amendment here, add that as the new number 5 renumber, and I'm asking that a second order amendment that we add 8,
Okay.
the language from the previous minute order. So it would read as Mr. Balgopalan stated, and then second amendment that we add this 8 from the previous minute order.
Okay. That'll be much more clearer then.
Okay, so Dr. Abraham, just so we're clear, the district has objections with what Mr. Balakapalan proffered as an amendment, but no objections with the language that was previously encased within the conditions that dealt with meet and confer. It appears very laborious to have both. Ms. Verdugo-Peralta, your thoughts?
The district, Mr. Jones also wanted to add.
Well, Mr. Jones said he did not have a problem with Mr. Balakapalan's proposal. So we should just go forward from that. The only other thing I wanted to address is that quarterly, I don't know whether the engineers would be in agreement with that, because normally things are handled monthly. I know that there's of course, it's easier to just do it quarterly, but to go along with how the AQMD normally gets communication from a company, it is monthly. So I
Mr.
would not
Jones.
agree to quarterly.
Okay, thank you. Mr. Jones, your thoughts on 5 plus the meet and confer?
The language proffered by Mr. Velagopoulos, in terms of the NRA providing the district with updates, we don't have an issue with the timing. If they think quarterly would work better, monthly is the norm, but I don't know. After speaking with staff, we could probably work with quarterly if it's prohibitively difficult. But beyond that, no, we don't have a problem. We're certainly receiving data. We've already been asking for the data, so it's really like an additional burden.
All right, so Mr. Balakaplum, why don't you completely lay the motion on the floor with the monthly updates as well as the condition as cited.
Okay. So before I make the motion, I would just like to reiterate that I too can make the 6th finding that Ms. Goldston made, that the petitioner is in violation of the rule 2012 C3A for not able to transmit data real time to the AQMD antiquated system. I'll add that. The compliance is beyond the reasonable control, as we heard. The theft of the copper lines have really resulted in the inability of them to transmit the data. And the closing or taking without the harm to the petitioner will overweigh the benefits to the air quality if the variance was denied. So the rest of them are regarding excess emission, so there's no excess emission we expect. And then the previous condition that they will report in the event that the CalISO just ask them to run the turbine, they will then report those emissions as using the missing data procedures. So, and that's how they'll quantify those emissions during that period. So I have no, I too can make the 6 findings. So I will go ahead and make the motion. Just and I'll
wait. I'm sorry, Mr. Balakaplum. Hold on 1 second. Let me just add this 1 point. We cannot go retroactive on the start date. So the start date will go for a calendar year commencing November 3rd through 2025 through, excuse me, November 3rd of 2026. We cannot go retroactive.
I'm sorry, I didn't get the motion regarding the date. It's starting today till, so I was going to make a motion starting the variance starts today because it's a new variance.
Okay,
until, okay. So in the matter of Henry Holdings LLC, case number 6248-4, I move that we regular commencing today and continuing to October 29, 2026 from rules 2012 C3A for gas turbine device D19 for the facility located at 17171 South Central Avenue in Carson, California 90746. The equipment is the gas turbine device number D19. The conditions are as set forth in Exhibit A, and I'll read to the record again condition, proposed condition of 5, and also add condition number 8 as Mr. The doctor mentioned. So condition number 5 is petitioner shall provide, and I think, Chair, you said monthly, so we'll stick to monthly updates to the reclaim, the reclaim Q&A, AQMD, and Thomas Lee at AQMD.gov and the clerk of the boards regarding the replacement of the new SAM/DHS system, period. This would include status of the SAM's DH application for SC-AQMD approval and dates of meetings, emails with the AQMD staff, and purchase orders and installation of the new system. And then we'll add condition number 8 which on the previous order, and condition number 8 says, let me read that. Edit here. Huh? Oh, condition 8
Grant.
will be, the parties shall meet and confer to explore alternative methods to communicate data to the South Coast AQMD. And that concludes
I
my
second the
motion.
motion.
Second.
All right, the motion has been properly moved as well as second. Mr. Munoz, I just have one quick question out of order, and I do apologize. In the minute order that you received, did it detail when you were to reply or apply for the new variants?
Yes, sir. It gave us a date of early September. I don't remember the exact date, but it was specific.
And did you apply?
We
then?
did not. We did not. We had not met and conferred, and we were not done with our technical analysis, so I missed that deadline.
Okay, so I just want to be very clear here, right? I want to be very clear. There were some steps that y'all didn't take. And I don't want this to be this onerous responsibility that's placed upon the district on this occasion. I remember very vividly relative to the minute order because I signed it. And so when there are dates that are placed within these various orders, I would emphatically encourage you to respond in a timely manner. Because I don't want anybody listening or watching this video after the hearing is concluded and believe that the district did something that was an error. That said, we're going to move forward. The motion has been properly moved as well as second. No further discussion on the matter. Dr. Abraham, your vote?
Aye.
Mrs. Verdugo-Peralta?
Aye.
Mr. Balaka-Palan?
Yes.
Mr. Pearman?
Aye.
Ali votes in the affirmative. The matter is hereby approved unanimously. This matter is hereby adjourned at 10:42 a.m. and off the record.